starting in 5 seconds. The suit is filed a good 4 years prior to even the expiry of 10 years. She attacked the finding of the High Court that the second defendant was not a bona fide purchaser for value. She pointed out that as far as knowledge of pendency of suit is concerned, the evidence pointed to the second defendant not being aware of the suit. Defendant 1 bracket B has admitted to not disclosing about the pendency of the suit to the second defendant. The second defendant inspected the site and found it to be a vacant land except for a small shed. Regarding the finding of the High Court that the original document evidencing delivery of possession of the plant schedule property by the BDA to the first defendant was not given to the second defendant, and that only a photocopy was not given. It is contended that second defendant was informed that the original was lost. There was already an assignment in favor of defendant 1 bracket B. There was no need for the second defendant to make any further inquiry. All possible inquiry was conducted by the second defendant. There is no justification for the High Court to conclude that second defendant was not a bona fide purchaser for value. As far as finding of the High Court that the second defendant are 20 years old at the time of the sale did not have the wherewithal to purchase the property, it could not justified having regard to the evidence which established that the second defendant was the owner of 10 acres of land. He was into the business of selling milk and he had the necessary funds, and there is no occasion for the High Court to interfere with the findings of the trial court in this regard. The learned senior counsel for the plaintiff reminded us that matter is appreciated by the two courts. The finding that there was a valid contract by the trial court was not challenged by the appellant. There is no pleading to justify the argument that the agreement in question was not lawful. The lease cum sale agreement nor the rules prohibited for an agreement to sell the site. He pointed out that the rule which is relevant to the fact is Rule 17. Even Rule 18 relied upon the appellants did not stand in the way of the agreement to sell or the sale in favor of the plaintiff. He also emphasized that it does not lie in the mouth of the appellants to invoke the preposition that agreement in question was unlawful. He pointed to the finding of the High Court that by his conduct there was complete absence of bona fides in the claim. He pointed out that a correctly found by the High Court doctrine of lis pendens applies. He further submitted that, at any rate, if the court found that lis pendens did not apply, the fact that the second defendant has not been found to be a bona fide purchaser for the value was sufficient for this court to decline to interfere, particularly in a jurisdiction which originates from the grant of special leave under Article 136 of the Constitution of India. He would refuse the contention that the suit was not maintainable, and further that it was premature. He would point out that confronted with the definite stand of the first defendant, who he points out was the wife of an MLA and also a minister, and having regard to Article 54 of the Limitation Act 1963, had no choice except to rush to the civil court and institute the suit. He would rely upon large body of case law, including judgments of the High Court of Karnataka, to contend that an agreement to sell in circumstances such as obtaining in the present case was valid and lawful. He would command for our acceptance the findings of the High Court regarding the fact that second defendant was not a bona fide purchaser for value. He did not have the necessary capacity, and he was fully aware of the pendency of the suit. The City of the Bangalore Improvement Act 1945, going by the preamble, was enacted for the improvement of the city of Bangalore and to provide space for its future expansion. It's contemplated the appointment of a board of trustees, which was to consist of 11 trustees, with the chairman and 6 trustees being appointed by the government. The Act clothed the board with the power to undertake improvement schemes. What is of relevance to the present case are the following provisions. Section 24 read as board not to sell or otherwise dispose of sites in certain cases. The board shall not sell or otherwise dispose of any sites for the purpose of constructing buildings thereon for the accommodation of person until all the improvements specified in section 23 have been subsequently provided for. The estimates this provision was to followed in all the cases which come under these jurisdiction and legal action accordingly being taken. Stop.